Representative Noel.
Thank you, Mr. Speaker. Pro Tem, I move to uncircle first substitute House Bill 99, bigamy offense amendments.
That motion is in order. Discussion to the motion to uncircle. Seeing none, all in favor say aye. Aye. Any opposed? Rule that motion passes and the bill is uncircled and properly before us. Go ahead, Representative.
Thank you, Mr. Speaker, Pro Tem, and members of the body. I appreciate the opportunity to run this bill again this year. As many of you know, we passed this very similar bill out last year. We've made a few modifications to them, which I think makes it a better bill. Actually passed out of the House 59-16 and then died on the Senate floor towards the end of the session. What this bill does and why the reason for this bill is this. When Utah became a state, one of the requirements in our Enabling Act was to forever prohibit the practice of polygamy. That's part of our state constitution. It was part of our requirements to enter the Union. About a year ago, a little over a year ago, a case was brought to us, an action was brought against Utah County by a group of individuals. The Cody Brown sister wives, you've probably seen them on TV, and the case was that part of our statute was in fact unconstitutional. That case actually ended up in district court, and Judge Wattops, federal judge, said that part of the statute, I'll read this from line 25 of the bill, a person is guilty of bigamy when knowing the person has a husband or wife, or knowing the other person has a husband or wife, and the person purports to marry another person or cohabitates with another. That's the part that's outlined, another person or cohabitates, because that portion of the statute, the cohabitation portion, was ruled by the judge to be unconstitutional. So we changed that word, and this was essentially all of last year's bill from or to and cohabitates, which makes the statute then legal. It puts it together, and it doesn't conflict with the Lawrence v. Texas case to the Supreme Court that said cohabitation is not a crime. So that would make our statute legal. It would make us comply with the Supreme Court, with our constitutional requirements in our Enabling Act. This case actually went to the 10th Circuit, and it was remanded back, not on the facts of the case, but on the fact that the case was not ripe for discussion. There was no case or controversy, and it came back that the case was remanded back because there was actually no action taken against Cody Brown and his wives. He's since left the state. They appealed that case, however, to the Supreme Court, and they refused to grant cert on it. So it's still there. The decision is still there that our statute is unconstitutional, which makes us out of compliance with our Enabling Act. And that case cost us over $1 million to prosecute, $1 million to defend that case. So it's just a matter of time before it comes back up again and someone else uses that defense. So if we fix this, we cure that. In looking at the statute and doing a lot more research and examination, we found out that this particular crime, which it is a crime today, this seems to be a misconception. Today, right now, polygamy is a felony. We are not raising the penalty. We are not changing the penalty for the practice of polygamy. However, in this bill, we do enhance the penalty, and we provide safe harbor for those that want to get out of it, like Michelle Nielsen. So bigamy then is a third-degree felony, and it becomes a second-degree felony if the accused is also convicted during the same prosecution of the following. Line 31, inducing marriage or bigamy under false pretenses. Number B, fraud. I'll just say this on fraud. There's a tremendous amount of fraud that goes on with religious organization. You've all read about the fraud that occurred in Hilldale and Colorado City with the Jeffs group, the fundamentalist Mormon group, where they took food stamps and were able to convert the monies in a store that they own, the food stamps, into monies and bought equipment, tractors, and other things. That also involves fraud in terms of competition. If you're a builder and you have to compete against a group of individuals that are in a polygamous organization, you'll find it's very, very difficult to compete against children of the polygamous father that are neither paid nor appreciated, work many, many long hours, and they don't pay any of the penalties or any of the requirements of taxes and unemployment compensation. So that's another part of the fraud. Domestic abuse. That occurs, we had much testimony on this, and domestic abuse, of course, it occurs in every home, but it's also very rampant in polygamous relationships. Child abuse. Again, I've mentioned some of those. I had a good friend of mine that he said he actually got out of polygamy mainly for the reason that he couldn't find a wife, because all the younger girls are taken very young age, some as young as 10 years old. Michelle tells me that her first marriage was 12 years old. So child abuse occurs, but also the working occurs. But Rocky Stubbs told me that in his situation that he would go out and work, and they had contracts to build fences. And by the way, he's a tremendous worker. One thing he knew how to do was work. He's very successful. He has a farm out in Kansas now, and very successful. But he never got the paycheck. He'd signed the paycheck, because a lot of these were government paychecks that came from contracts, and then he said, "Dad, one day can I hold it for a minute before you take it away from me?" You got a very minimal wage, and that happens today. Some groups are organized such that all of the monies they received is in a script, and they have to buy their clothing, food from the store of the owner of the organization or the group who's called the prophet or the leader of the group, and buy. Human trafficking. This is what happened to Michelle. She was passed around from group to group. I mentioned some of those, used in horrific ways, in ceremonies and other ways. Human smuggling, same thing. So those are the ones that require a higher degree.
Excuse me, without objection, we'll grant you another 2 minutes, Representative.
Thank you. The second part of this is, if you look down on line 41, it says, the accused is a person. This is the last one. The accused reasonably believed, on 39, that the accused and the other person were legally eligible to marry. So that's a defense to bigamy. These are amendments that my good friend from Washington County included, and they were accepted by the committee. The second one is the accused is a person who, under reasonable fear of coercion or bodily harm, left a bigamous relationship as defined in subsection 1, or the accused is a minor who left a bigamous relationship as defined in subsection 1. So essentially, Mr. Speaker, Pro Tem, that is my bill, and I would ask for support, and I'm open for any questions or comments on this bill.
Okay, thank you, Representative. Discussion to the bill. Representative Nelson, you are first. Did you?
Yeah. Thank you, Mr. Speaker Pro Tem. I do have a couple of comments or observations. This is a difficult bill, a difficult subject that we've all dreaded having to face. I think we all acknowledge the sincerity of the sponsor and the evils to which the bill is directed. We have no question about that. And so I just want to provide somewhat of a historical or legal perspective on the bill. First of all, from the historical perspective, many of us have ancestors who are involved in this practice under what they considered to be a religious obligation, and they were not evil people. And so I want to first stand to vindicate my ancestors. They were not criminals. There was nothing licentious or evil about what they were doing. And so plural marriage itself alone is not inherently evil. Evils can be associated with it as it's carried out. But the reason it's outlawed here is because of a federal mandate that was a condition of our statehood, which today would not be upheld. It would be in violation of the equal footing doctrine and equal protection doctrine in the Constitution. And so a federal mandate that we as a state outlaw certain behavior would not be enforceable. With regard to the statute and plural marriage specifically, I want to refer you to the marriage statute. So what we're dealing with here is the criminal code. But if you look back in Title 30, the marriage code, plural marriage is impossible. Plural marriage cannot happen because any married person who attempts to marry a second time, that second marriage is void ab initio. It cannot happen. It's impossible for a married person to marry someone else. And so we're talking about a legal fiction. That's why in the code, line 26 uses the term purports to marry, because no one can legally marry a second time. All they can do is think about it. All they can do, if you have a married person who thinks he is marrying someone else, he's purporting to marry a second person, that marriage is void under the marriage law. And so what we're really doing here on line 26 is criminalizing his thoughts. It's a thought crime. We're penalizing him because he thinks he's married to a second person. So under the law, if we take it on its face, and first of all, let me mention as well, this statute, I think as the sponsor explained, and I may not have a perfect understanding of it because I haven't gone back and read all of the cases, but my understanding is that the statute was struck down in federal court because of the cohabitation provision. In other words, we cannot outlaw cohabitation. But that ruling was reversed in the 10th Circuit on lack of ripeness because no one had been prosecuted for cohabitation. And so the 10th Circuit said, we don't have to strike this statute down, it's never been used. And so our statute is in the same position it was before we started, and the U.S. Supreme Court denied cert. And so we still have the same statute here, and I'm questioning whether we have a need to address this at all. But if you look at the statute as it is, I see a serious equal protection problem if we pass this bill. If you have two men, if you have married man A who cohabits with another woman, he can do that. He cannot be prosecuted under the statute because he's not purporting to marry the other woman. He's a married man cohabiting with a second woman. And so he cannot be prosecuted. Whereas if you have married man B who purports to marry a second woman, he can be prosecuted. And so you have married man A, married man B doing exactly the same conduct, but only married man B can be prosecuted, and he's being prosecuted because of what he thinks, because he purports, because he thinks he's married to a second woman. And so I see a serious equal protection problem. One is being or could be prosecuted, while the other doing the same thing could not be prosecuted. On top of that, married man A, who merely cohabits, if he engages in child abuse or sexual abuse, number one, he can't be prosecuted. Even if he could be, his penalty could not be enhanced because he's not guilty of bigamy. So I see serious equal protection problems with it. A final comment is, I recognize the serious evils that we're trying to address here. Those evils are all outlawed by separate statutes. Fraud in marriage, domestic violence, child abuse, sexual abuse, human trafficking, human smuggling, all of those are prohibited prohibited under separate criminal law sections. And so we don't really need to target them through a bigamy prosecution. We can go directly and prosecute them directly for what they are. And so I question the need for the bill. I'm not inclined to support it. I think that concludes my statement. Thank you very much.
Thank you. Further discussion to the bill. Representative Polson.
Yes, thank you, Mr. Speaker. It's very interesting to listen to this debate. From a personal perspective, I can argue both sides of this bill. Like many of you, I have polygamous ancestors. In fact, my great-grandfather was a LDS General Authority and was chosen by the LDS Church to be the test case for polygamy. And so that case, Reynolds versus the United States of America, went all the way to the Supreme Court and is still studied today in law school as a landmark case as far as religious freedom and family law. And so certainly those people were not bad people. My great-grandfather lost that and served time federal penitentiary in Leavenworth. And I'm not that upset about having that in my history because I got a beautiful grandmother out of it, but many of us have that. But also in my neighborhood in Cottonwood Heights, until 2000, we had a large number of polygamous families along Danish Road and at the mouth of Little Cottonwood Canyon. And so over the years, I've interfaced a lot with the women and children in these relationships, and then also have taught many of the children of those relationships in schools out in South Jordan and Riverton and Harriman, and have observed a lot of things that trouble me and situations where I feel are abusive. And so because of that, I'm torn with this bill. I'm considering voting for it because here's the general question I want to put out to our legal minds who are already discussing this bill. Which scenario puts us in the best position to protect these women and children and address their needs? And so as this discussion continues, I would like those that speak to this to address that, because certainly whether we pass the bill or not, what we need to do is put us in the best position to address the needs of those women and children and young men in those relationships. So thank you.
Thank you. Further discussion to the bill. Representative Brian King.
Thank you, Mr. Speaker. My appreciation to our good friend from Kane County who has had the courage, and that's what it has taken, to bring this bill up and to present it to us for debate. This is just, from my perspective, extraordinarily complex. It's got, as was alluded to from by our friend from Tooele County, it's got deep historical, religious, cultural, legal, and moral components to it. And it's tough. And I wish it were as simple as what we tried to do last year when our good friend from southern Utah tried to simply change an and, rather change an or to an and. If we could solve this problem easily, quickly, by doing that, I'd vote in favor of the bill. And you do solve one problem by doing that change, in the sense that you make it more likely to withstand constitutional challenge by making that change. When you change the or to and, it undoubtedly strengthens the ability of the AG's office to defend the constitutionality of our anti-polygamy statute. And that's, the Constitution, the state Constitution says what it says, and it makes it very, very clear in no uncertain terms that Utah does and shall forever disclaim and prohibit, make illegal polygamy. So we're not going to get around the state statutory the state constitutional language, but we still have to deal with this more fundamental question that presents to us as legislators whether prohibiting polygamy is a violation of the U.S. Constitution or contrary, whether Reynolds, a Supreme Court case from the 19th century, is still good law. And there are a lot of people who cast doubt on that question about whether Reynolds is good law. I think what's important from my perspective is to point out that all of the separate offenses, this has been pointed out by others, but all the separate offenses listed on lines 31 through 37 of the bill, of the first substitute, are separate crimes that can be separately prosecuted, and for most of them are regularly prosecuted. We have prosecutors that regularly charge and try cases involving fraud, domestic abuse, child abuse, sexual abuse, human trafficking, and human smuggling. All correctly, rightly done, necessarily done. That will continue to need to necessarily and appropriately be done in those situations where those crimes exist in the context of polygamy. I don't think anybody in this chamber would disagree with that. I'm grateful for the good work that law enforcement and our prosecutors and our courts, our judges, our juries do in sorting out on a case-by-case basis whether those particular crimes exist and have been committed in the context of polygamy, as well as in the context of non-polygamy situations. And that causes me to believe that we just don't quite have right at this point the balance that we need to strike. The amendment in committee moved us in the right direction, I think. And you'll see that on the system, that it includes language that allows for greater levels of comfort and protection to be given to an individual, an adult in a polygamous relationship, to have a defense based on their good faith desire and effort to protect the safety and welfare of a minor child. That's a positive step, because one of the problems with invigorating and strengthening our polygamy statute is that there are a lot of innocent lives that are negatively impacted when you raise the prospect and the fears that the state of Utah is going to more aggressively prosecute polygamy. A lot of innocent lives, a lot of children, and there are a lot of arguments that can be made that right now those children are subject to abuse and are being abused in some cases. I get that, that's true. But does a more aggressive prosecution stance toward polygamy make it more or less likely that those kids in the future are going to be abused? There's a lot of feeling that to more aggressively in the future prosecute polygamy, or to put on the books laws that allow for the more aggressive prosecution of polygamy into the future, makes it more likely that those individuals, the kids particularly, and the wives who are relatively at the mercy of the controlling individual who controls the family and the community, the hierarchical community of men, as it almost always is, who control that community, whether they will be driven underground, whether in fact they'll be harmed when you more aggressively prosecute polygamy. There are a lot of folks who deal with this area of law on the ground every day who say that's going to be the result if you even change the law to give the tools to the prosecutors to do that. Regardless of whether the prosecutors actually do it, when you give the tools to the prosecutors to do it, and it's publicized when the Tribune and the Des News say, you know, the legislature passed and the governor signed strengthened laws on polygamy, what's the effect? There are a lot of people that say, I'll tell you what the effect is. It's going to be to drive it even more deeply underground than it already exists, in a way that harms the lives of these women and these children. Now, who's right and who's wrong? I don't know. It might vary on a case-to-case basis. For some families, it might result in kids and susceptible individuals being more harmed, and for other families, it might result in being brought to light in a way that vindicates them and releases them from shackles that would all look at and say, oh boy, you're lucky. That's my point, that this is such a difficult area. It's so complex. It's so difficult to figure out. I just don't think we have it quite right yet. I just don't think we have it quite right yet. I was interested to hear our friend from Tooele, Grantsville, actually say that in his mind, polygamy is not inherently evil. Well, I don't know. I mean, some people would say it is. I don't know. Certainly in our history as a state hasn't been. It was sanctioned by, of course, the LDS Church for many years. But here's the question, regardless of whether you think it's inherently evil or not, what we're doing when we pass this legislation, in accordance with what our state constitution requires, is you're strengthening the ability of prosecutors to go after it with hammer and tongs. Good thing or bad thing? I'll leave it for you to decide. But I think that we need to take a more careful approach to how we deal with this statute than I see in the bill right now. And I say that with the greatest respect and regard for our friend who is the bill sponsor. He's worked very hard on this in good faith, in an effort to strike the right balance. I just don't know that we're there yet. Thank you.
Thank you. Further discussion to the bill. Representative Green.
Thank you, Mr. Speaker. You know, this has been an interesting session for me in one respect, and that is that I found myself on the opposite side of some hotly debated issues with my good friend from Kanab, the sponsor of this bill. And this is one of those issues. And this came before us in Judiciary Committee on 2 different occasions. We had some marathon meetings on this. And I tried a couple of times to amend the bill. I'm not going to do that again because I think I've reached the conclusion that I'm just opposed to making these changes. And that's not to diminish the evils that are often recited with being associated with this culture. Those are real, and those, in many instances, are severe, and we can't allow those to cloud our analysis of this bill. I'm going to talk a little bit about the constitutional prohibition that's been mentioned. Article 3 of our Constitution requires that the state forever prohibit bigamy or plural marriage. But that is not a mandate to criminalize behavior as we seem to be focusing on. The marriage statute, as our friend from Grantsville indicated, it creates a situation where any attempted second marriage is void as a matter of law. And so it is illegal in practicality to have plural marriages. And so that marriage statute in and of itself satisfies the requirement of the constitutional prohibition. But I think it's important to understand that arguing otherwise is a misunderstanding of the purpose of constitutions. Constitutions are not created among people to criminalize or limit the activities, the liberties of individuals, but to restrain the government. And if you take a historic look at our state's history with this issue, you understand and you realize that this prohibition came about during a time shortly following the efforts of the federal government to eradicate bigamy under the Federal Anti-Bigamy Act in the territory of Utah prior to statehood. And so in granting statehood to Utah, Congress was concerned that the state legislature would be immediately populated by Mormon men, and that they would therefore then try to create the legal structure for bigamy or polygamy. That is why the prohibition is in our Constitution. And again, the structure of our marriage statute qualifies and satisfies that constitutional prohibition by restraining the government from legalizing plural marriages. So what does this current bill do? If it can't address a legal fiction, what does it do? And our good friend from Grantsville spoke a little bit to that. I've got a little bit different take on it. If the action or the activity of cohabitation is not a crime, The only thing left being a crime is to cohabitate while speaking. Purport means to speak, to claim, to assert something. And so what becomes a crime here is the assertion that you have multiple spouses. That's not that's not a legal fact that you have multiple spouses, but what we would do here is criminalize, and what the statute already does is criminalizes your speech, the speech of those who want to claim that they have multiple spouses. That amounts to an unconstitutional prior restraint on speech in violation of the First Amendment. So I'm confused about the purpose of this bill and what we're really trying to accomplish here. The sponsor has said that we need to change this wordage or this wording so that we would avoid any future litigation. I contend that in taking this action, if we were to take this action, we would be inviting immediate litigation over the constitutionality of criminalizing speech. And I would also contend that we would lose that legal battle. So I would urge my colleagues to not accept the argument that's been made, to not pass this bill. And ultimately, what we probably need to do is find better ways to support and rescue those victims of abuses that are sometimes associated with this lifestyle, and to swiftly and severely punish the abusers. And we can do that without criminalizing speech. That would be my recommendation. Thank you.
Thank you. Further discussion to the bill. Representative Ivory.
Thank you, Mr. Speaker. I understand and I support the ends for this legislation. I don't know that we have certainty on the legal means for the legislation. We heard this 2 different times in the Judiciary Committee for 3 to 4 hours each, 2 to 3 hours each time. And I had the opportunity to ask the representative from the Attorney General's office to clarify what is taking place. And just to be clear, this is for me perfectly perplexing in what we're trying to do with this. If you have more than 2 people cohabit, there's no, the penalty could be fornication, it could be something else that would be a Class B misdemeanor, as long as they don't purport in any way to be married. If you have more than 2 people doing the exact same thing and purporting to marry, then that's a felony. What we heard in the consequences are in need of prosecution, in need of remedy. And there are sufficient legal tools, we heard repeatedly. In fact, even in the statute itself, if you look at the statute itself, the 101.5, the child bigamy, so all of the actions that relate to a child, and that's anyone under the age of 18, that's already a second-degree felony. And yes, that should be punished. Yes, that should be criminalized. The actions and the consequences. I echo some of the comments that from a legal certainty standpoint, I don't know how in a world where we've undefined marriage, I don't know how we say that 2 or more people cohabiting, where we take the and instead of the or. The effect of the and is to say 2 or more people cohabiting are no longer penalized, except for perhaps fornication, statutes like that would be a Class B misdemeanor. But we have the effect with the and of saying 2 or more people purporting to be married is now a felony. And I struggle with the legal certainty that brings. I applaud the ends. I think the ends in terms of this practice, the destructive nature of it. We've seen a great deal of that. We've heard earlier the stories of that. The law has tools already for prosecutors that want to pursue the harm that is happening, and I don't believe that to get the salient and I don't believe we have a legal certain means to get there with this bill. Thank you, Mr. Speaker.
Thank you. Further discussion. Representative Snow.
Thank you, Mr. Speaker. This is a difficult issue, and some of what we're called upon to decide here today and to vote on is a history that has gone on in this state for years in terms of trying to handle this issue, and I'm not certain that I can shed a lot of light on every historical fact that brings us to this point. But I will say this, we are all subject to the constitutional prohibition, and that's clear. And a prohibition is ineffective unless, especially on something like this, unless it carries with it a criminal penalty. So there is nothing about this bill that changes the level of the criminal offense. Whether it should be or not is not really before you today, because if you don't vote in favor of this bill, it remains on the books as a felony. We heard extensive discussion on this in our Rules Committee, and much of the discussion was brought by the Attorney General's office. The Attorney General, by provisions in the Constitution, is the legal counsel for the state of Utah. They are the ones, by constitutional authority, are the ones that advise the state and its officers on constitutional matters. The Attorney General's office representative who spoke on this issue and was involved in these cases made it clear that, in their opinion, it was important to support the sponsor's change to the law. So if nothing else, when this issue is brought before the courts, and by the way, it's not if it's brought before the court again. No matter what we do here today, it will be back before the court. One of the things that we get by making this change is we get that issue squarely before a court, not to allow any court to decide it on a technicality. More importantly, much of the discussion was centered around the really evil practices that oftentimes are associated with this polygamous practice. And I'm not going to say that everyone that is involved in it is evil, but I will tell you that we heard enough testimony that went on and on from people who had been involved in it, who'd been abused, to lead me to believe that if we simply stand by and do nothing, I'm not certain that that is the tack to take, that that's going to give law enforcement the tools it needs to help alleviate that situation, particularly for children. And I also felt strongly and supported the amendment. In fact, I made one of the amendments in the committee that we provide a safe harbor, because I want to believe, based on some of the people that I know that are involved in those situations who are good people, I want to believe that there are some that are looking for a path out. And while the safe harbor doesn't provide a perfect path out, there may be some who look at this law change who believe that at least they will be free from prosecution if they take steps to get themselves out and also to get their children out. And that's why the last safe harbor provision particularly relates to protecting the welfare and the safety of minor children. Because what's happening to the minor children is absolutely reprehensible in many of those situations. And I'm not certain that it is the best public policy of this state, with all due respect for everything that has been said, for us to say, let's not address those issues specifically, because if we do address them specifically, they're going to get worse. I have a lot of confidence and faith in law enforcement, and I have a lot of confidence in our prosecutors to do their job and to get at these issues. And if this law will give them that added measure, and that was the testimony from the Attorney General's office, then I support it. But let me end with where I began. This is not an easy issue. This is a difficult issue. And I'm certain that it will not be entirely resolved today, no matter which way we go. But I feel strongly about clarifying the law, making it clear. Number one, I feel strongly about enhancing the penalties for those who are evil and would use this practice to abuse others, especially children. And number three, I feel strongly that these safe harbors should be allowed for people getting out and for the protection and safety of children. Mr. Speaker, thank you for giving me some time.
Thank you. Further discussion. Representative Stratton.
Thank you, Mr. Speaker. Colleagues, I, in great respect and honor those that have spoken on both sides of this issue. This has been an extremely difficult and complicated issue. It's been heard by our Judiciary Committee, passed out with 7 votes in favor, 3 in opposition. I appreciate the work that they've done and the opportunity of the sponsor to bring it here before us, and certainly those who have commented today in respect. But I wanted to try and simplify things a little bit for us if I can, to try and help us not get caught up in the legal and minutiae sometimes that we can. As we look at polygamy, we recognize the important role that it has in our heritage of this state. And I would say that in my analysis, I would say that is virtuous carried to extreme can become very problematic. So, for example, 3 peaches on my bowl of ice cream is good. A truckload is bad of peaches on my ice cream. And I think what we're trying to deal with here is the criminal behavior that has come along with this extremity of application. We need to, in a surgical manner, address a problem that has been brought to us. And I appreciate the work of the sponsor in seeking to do so over the last 2 years. I would note that I appreciate the constitutionality and the concern of that, but I would note that this piece of legislation does not bear a constitutional note. And as it boils down to where the rubber meets the road, colleagues, I would say that if we're going to err, let's certainly err on the side of protecting children and protecting women who we honor and respect in the most highest manner. That's what I think this bill does. And therefore, I invite us all to make the hard decisions that our good speaker talked about and stand in support of this and allow a step forward to be made in this sphere. Thank you, Mr. Speaker.
Thank you. Discussion to the bill. Representative Winder.
Mr. Speaker, previous question.
Previous question has been called, has the effect of ending debate. Non-debatable motion. All those in favor say aye. Those opposed say no. Rule that motion carries. We'll come back to the sponsor for summation. Representative Noel.
Thank you, Mr. Speaker. Appreciate the discussion. I appreciate the comments both for and against. I have a few things I'd like to add to the discussion and clarify. I think I wasn't going to bring up a lot of discussion about my church, the Church of Jesus Christ of Latter-day Saints, but it was brought up in some context. First of all, I'm also a child of a polygamist background. My great-grandfather on both sides, both of them were polygamists. One went to jail, went to prison in Illinois, so I understand that. But I'm also going to read a couple of reports that came from the official statements of the Church of Jesus Christ of Latter-day Saints, and they involve a situation that happened in 2008 with the fundamentalist sect of the Church of Jesus Christ of Latter-day Saints, or the Mormons, which, I mean, they call them fundamentalist Mormons. And there's really a great outrage from my church from the fundamentalists using the name Mormons. That name, the Church of Jesus Christ of Latter-day Saints, and even Mormons, is attributable. And so an article came out in 2008 from Timothy Edgin, and wrote a post and claimed that the way polygamy is practiced today by members of the LDS sect in Texas is the same as it was practiced by members of the church in the 19th century. And much of the argument he made were the similarities between FLDS polygamy and early Mormon marriage practice relating to the claim of sexual manipulation of children by evidenced by the age of marriage. Now, that can easily be refuted, and it was, by historian Catherine Dames. It was unusual in the 19th century for a girl to marry at the age of 15. And I totally categorically deny that sexual manipulation, the things that are going on today, were part of the practice of the Mormons in the 19th century. He also portrayed Mormon LDS women as timid, subservient, and backward to the image of LDS women portrayed in recent days in the media. However, history paints a different picture. 19th century Mormon women in both plural and monogamous marriage were not just interested in raising family and blindly following their husbands, they were politically active and participated in territorial elections. Many were well connected with national women's organizations. These women also taught school and were active in publishing and literary activities. Some even served their communities by going to medical school and becoming skilled physicians. Because of their competence and level of self-reliance, they did not have to resort to public assistance. I say this situation that's occurring in our state, under our noses as legislators, is completely different. There's no similarities between the two. And the fact that individuals come up there and testify that they are FLDS Mormons insults me and bothers me. They are an apostate group, and they are no part of my religion. So does this bill strengthen the ability of Sean Reyes, our Attorney General, to prosecute? He tells me yes. He came to my office here last week and said yes. And his general counsel testified to that it strengthens our ability. This is not an open society. This is a closed, secretive society. The abuse is not being reported. And these abuses will go on. Polygamy is illegal in the state of Utah. It is illegal in every other state in the United States. The statute has been in place since 1935, but even before that, the statute in 1882, under the Edmunds-Tucker Act, was a felony. An act to punish polygamy and other kindred offenses was approved by the governor and the legislature, which expressly incorporated penalties and punishments regarding polygamous and bigamous relationships under the Edmund-Tucker Act. So we followed the federal act. And that was the controlling act statute until 1935, when Reuben Clark wrote this statute. All we're trying to do here, don't get sidetracked. We may err, but we're on the right side on this to pass this bill out and tell the women, like the wonderful lady sitting next to me, that we are going to continue to outlaw the practice of polygamy and bigamy in our state, and we are going to ferret out these men and evil organizations that are taking advantage of our children in what I call Utah's version of crime, of organized crime, which it is. This is Utah's version of organized crime, what's going on in these sects and groups. And we can ferret it out, and we can do a better job here in our state. We don't need to go anyplace else. We need to start right here in our own backyard. Let's send that message. Thank you.
Thank you. Voting will now be open on first substitute House Bill 99, bigamy offense amendments. Seeing all present having voted, voting will now be closed. First substitute House Bill 99, having received 48 yes votes, 25 no votes, passes this body, will be transmitted to the Senate for its consideration.